Since 2018, Maternity Action has had a specialist advice service for women who have been charged for their NHS maternity care. In 2023, my team advised over 530 women and took on over 80 cases for casework. We're the only team in the country who provide this in-depth legal representation and advice. We made a decision that the team should be made up of solicitors and advisors with an immigration and asylum law background. And we made this decision because NHS charging law can be complex, as it requires the overseas visitor team at the NHS Trust or us as practitioners to understand a person's immigration status and history in order to advise them whether they are chargeable or exempt from charges. One of the challenges for us as a legal team is trying to understand why this is an area of law that overseas visitor teams find so challenging to apply in practice. From our perspective as immigration advisors, it's very straightforward. When an individual provides an overseas visitor team with the reasonable grounds decision, that is all the evidence that is needed that someone is exempt from NHS charges. However, in practice, it becomes much more complicated, with overseas visitor teams asking questions about an individual's immigration status and about their purpose for being in the UK when they first arrived. Neither of these things have any relevance to whether they are exempt because they are a survivor of trafficking. I'm just going to talk you through the two ways that a survivor of trafficking can be exempt. So it's a two-stage process. If an individual has a reasonable grounds decision, they become exempt for any care they receive from the current time until the point that they receive a conclusive grounds decision. Also, they can look back, and if they have any previous NHS invoices for care received, they can ask the overseas visitor team to have those invoices cancelled. The cases that we take on for casework are where individuals either don't know that they have a right to have their charges cancelled, or where other organisations refer us victims of trafficking where they've tried to advocate on their behalf but haven't been able to get the overseas visitor teams to understand the law. The Department of Health and Social Care has produced very helpful detailed guidance for NHS trusts to help their interpretation and application of the NHS charging regulations. Included in the guidance is a section about how to identify and apply the law to victims of trafficking. Regulation 16 states that if a survivor of trafficking has had a positive reasonable grounds decision, they are exempt from all future NHS charges until the point of a conclusive grounds decision and all previous NHS charges. It's really complicated, however, in practice for survivors of trafficking to assert their rights successfully. For example, if a woman gave birth 5 years ago to her baby, and at the time she had her baby, she was undocumented, and she has a bill for around £7,500. If she's later recognised to be a survivor of trafficking, that bill becomes exempt. The woman becomes exempt from charging. But there is a process for her to follow in order to have the NHS Trust cancel the invoice. The woman needs to proactively contact the overseas visitor team, provide a copy of the positive reasonable grounds decision, and ask the NHS Trust to cancel the invoice. One of the challenges we find is that women are not told that there is an exemption for victims of trafficking. And when they receive their positive reasonable grounds decision, the Home Office don't notify the individual that they are now exempt from NHS charges. Additionally, the Home Office doesn't notify NHS trusts that this is a survivor of trafficking and therefore should have any previous invoices exempted, and there's no flag put on that person's system. So it requires the individual to be able to self-advocate and understand the law and how it applies to them. Overseas visitor teams often ask survivors of trafficking what their immigration status is in order to understand how to apply this exemption correctly. However, in practice, there is absolutely no link between an individual's immigration status and whether they are exempt under Regulation 16 as a survivor of trafficking. It's one of the frequent misunderstandings and one of the reasons why survivors of trafficking are often told that they cannot be exempt from NHS charges. When a person receives a reasonable grounds decision, the effect for NHS charging is that they then become exempt from all NHS charges for any care they receive. And looking back to their past, if they have had any invoices or if they have been charged for any previous care, they can ask for those charges to be cancelled. This is the preliminary stage. The next stage is that the single competent authority, which is a decision maker in trafficking cases, decides whether there are conclusive grounds that this individual is a victim of trafficking. If there are conclusive grounds, then that individual remains exempt from charging for the future and will never become chargeable for their care. If the decision maker refuses to accept there are conclusive grounds that the individual is a victim of trafficking, from that point onwards, they become chargeable for any care they receive unless they fall in any exempt group. Best practice that an NHS trust could follow when assessing a survivor of trafficking is to, first of all, accept the reasonable grounds decision, write to them to say that they are exempt from current NHS care, that the NHS trust has cancelled any previous invoices issued to them, and to confirm that they've put a flag on their system that this person is exempt from charges. The first time I saw that an NHS trust had applied the law incorrectly for a survivor of trafficking, a woman contacted us on the advice line and she told me that she had been stopped at the airport. She had been detained with her small child on return from holiday, and she was told about an invoice she didn't know she had from a large London hospital. She'd never received a bill. She was undocumented at the time of her maternity care and had moved around many times. And so any bills had gone to a previous address. We spoke on the telephone, and when she told me about her history, she mentioned that she had had a successful trafficking claim. Now, she did not know that there was any link between the fact that she was a survivor of trafficking, which had been recognised, and the NHS invoice, which she was told about by the immigration officer. It was entirely coincidental that during our conversation she mentioned this, and I was able to make submissions to the NHS trust that the invoice should be cancelled. Now, this was a very large London NHS trust with an overseas visitor team that issued many invoices for care. And I was really surprised to see that the response from the overseas visitor manager was that she was not exempt from the charges because she didn't have a conclusive grounds decision. She had a reasonable grounds decision. This was a mistake in law, but the effect for this woman, had she not had a legal representative, would be that she would have accepted the overseas visitor manager decision as final. So first of all, she didn't know that she was exempt. And secondly, the overseas visitor manager didn't want to or didn't apply the law correctly to her. I was able to go back, alert him to the guidance, and he apologised and said that he now understood. Now, this was a flexible overseas visitor manager. We have other cases where overseas visitor teams have been entirely fixed in their position of not applying the law correctly to this group of women. If a woman is told by an NHS trust that she is not exempt because of the reasonable grounds trafficking decision, she is left with the NHS invoice for her care. First of all, this is an invoice which should be cancelled, and she's going to have to repay this debt. It's very challenging for women to negotiate low repayment plans with NHS trusts. Often, trusts expect women to commit to repayment plans of hundreds of pounds each month. Additionally, there are potential immigration law consequences and implications of having an NHS debt. We know that women are stopped on return to the UK, having travelled outside of the UK, and questioned about any NHS debts. The implications are huge, and it cannot be underestimated how stressful it is for women to face a barrage of calls and letters from debt management companies threatening court action, telling them that their immigration application is going to be refused because of this debt. A case that I worked on recently was referred by a specialist immigration advisor who had tried and failed to make submissions to an NHS trust that her client be exempt because she was a survivor of trafficking. The NHS trust repeatedly refused, set out the legal position incorrectly in detailed emails, and there was absolutely nothing that this legal representative could do to get the overseas visitor team to correctly apply the law. Maternity Action took on the case, and we made submissions again to the overseas visitor team that here was a survivor of trafficking. This was evidence in her reasonable grounds decision, and this was the law. We set it all out in a detailed letter. The overseas visitor team came back to us straight away and said, as the woman didn't have immigration status, she was not exempt. And they said, we've referred her to a debt management agency, they'll be in contact, and she will have to agree a repayment plan. We reiterated the law, set it out again in an email, asked for the overseas visitor team manager to look at it, and again, we were told exactly the same position. We had to escalate the case to NHS England, and it was only then that the invoice was cancelled.